Without further ado, we would like to welcome our keynote speaker, Richard Rothstein, to the stage. Mr. Rothstein is an author, Distinguished Fellow of the Economic Policy Institute, and a Senior Fellow of the NAACP Legal Defense and Educational Fund. He published the widely acclaimed Color of Law in 2017 and has recently published with Leah Rothstein, Just Action, How to Challenge Segregation Enacted Under the Color of Law. His work and advocacy dive deeply into the history of segregation in the United States as a means by which to reflect on the policies and laws that continue to divide our society. In some of his most notable works, which you can purchase at our pop-up bookstore through lunchtime, Mr. Rothstein has thoroughly examined the racial segregation of our communities, an issue that has long been attributed to barriers outside the law. Through his work, Mr. Rothstein has highlighted the significance of de jure segregation, that is, deliberate segregation by the law to push for justice and socio-political change. We are thrilled to welcome Mr. Rothstein.
Thank you very much, Ms. Casey, Dean Nelson, Professor Levin, and all of the editors of the Law Review for asking me to come here today to share these remarks with you. Let me get right into it. In 1865, Congress and the states adopted the 13th Amendment. Section 1 of that amendment banned slavery. Section 2 authorized legislation to enforce the prohibition. In 1866, using its Section 2 power, Congress passed the Civil Rights Act that outlawed burdens on freed slaves that were not imposed on free whites. It reasoned that racial discrimination, public or private, undermined effective emancipation. It was a racially explicit law. Along with other provisions, the act said that all persons should have, quote, the same rights as white persons to buy or sell property or otherwise participate in the private market. President Andrew Johnson vetoed the law. Congress overrode his veto. In that same year, partly to clarify the racial equality explicitly protected by the 1866 law, Congress adopted the 14th Amendment that defined emancipated slaves as full citizens and prohibited their unequal treatment. The 14th Amendment was ratified by the states in 1868. To avoid any further doubt, Congress then reenacted the provisions of the 1866 law in the new Civil Rights Act of 1870, now also claiming the authority of the 14th as well as the 13th Amendments. Another civil rights law, adopted in 1875, prohibited private discrimination in public accommodations such as hotels. In 1883, the Supreme Court agreed that the 13th Amendment's Section 2 power could indeed be exercised to prohibit continuation of what it called, and I quote, the badges and incidents of slavery. In other words, any form of second-class citizenship of the formerly enslaved population. It recognized that a prohibition on holding property could be understood as such a badge, but the judges went on to say that the Constitution could prohibit only discrimination by government, not by individuals. In 1896, the justices added that even government-imposed racial segregation did not violate the amendments because forced separation of the races was not necessarily unequal. That's the Plessy v. Ferguson decision, which you're all familiar with. Justice John Marshall Harlan dissented in both cases, showing that the 13th Amendment, the 1866 law, the 14th Amendment, and the 1875 law were all legitimate exercises of federal power to eliminate not only state but private perpetuation of the badges and incidents of slavery, including discrimination in commerce by individuals and corporations. He effectively exposed the racial hypocrisy of the other judges, observing that prior to the Civil War, Congress passed laws protecting the right of private bounty hunters, employed by slaveholders to capture runaway slaves, even when state government was not involved. If justices recognized that Congress had the right to prohibit interference with private slave-catching activity, Justice Harlan noted, surely they could accept the same right now to prohibit abridgment by private citizens, individuals, and corporations of black citizens' private sector rights. If the 1866 law and its successors had been honored, we would not today be a residentially segregated society. The resulting racial inequality would be much diminished. But over the course of the next half-century and more, federal, state, and local governments enacted blatantly unconstitutional and unlawful policies that denied entirely to African Americans some benefits that whites enjoyed, provided other benefits to black citizens on dramatically inferior and unequal terms, and blessed private racial discrimination without meaningful restriction. The badges and incidents of slavery flourished. The result was not only a rigidly segregated society, but a black population that was packed into overcrowded ghettos, denied employment opportunity, except in most menial and servile jobs, prohibited them from attending well-resourced schools, and in almost all cases, institutions of higher education. To be clear, I want to say again, the 1866 law was racially explicit. Its incorporation into the 14th Amendment was not, as today's Supreme Court majority would have it, intended to be race-blind. The law stated that former slaves shall have the equal benefit of all property rights, private and public, as is enjoyed by white citizens. Not only was the emancipation won in the Civil War thus annihilated by the Supreme Court, as it blessed the imposition of second-class citizenship on African Americans, we all then rationalized the resulting segregated and unequal residential landscape with a national myth. We told ourselves that it must have happened naturally, by accident. The term we use is de facto segregation, the consequence of private bigotry by homeowners and landlords who wouldn't sell or rent to black households in white neighborhoods, or the discriminatory policies of banks, realtors, insurance firms, or the private sector businesses, or the individual preferences of whites and blacks to live with same-race neighbors. In 2017, as you've heard, I published a book, The Color of Law, whose purpose was to demolish this myth of de facto segregation. The book demonstrated that it was not private activity that created our nearly apartheid system of neighborhood segregation, but a blatantly unconstitutional, unlawful, and racially explicit program at all levels of government to impose residential inequality. Private discrimination was rarely independent of government requirement, and racial bigotry could not have found its powerful expression without the blessing of federal, state, and local laws and administrators acting in their official capacities. State licensing agencies, for example, violated their 14th Amendment responsibilities by consistently certifying real estate agents who subscribed to their National Association's Code of Ethics that prohibited giving African Americans access to white neighborhoods. Only a few prominent license denials in the course of the 20th century would have brought an end to the discriminatory system. Public agencies, federal, state, and local, imposed racial segregation in public housing, sometimes creating greater inequality and greater separation than previously existed in the neighborhoods where the projects were constructed. Most of us probably think of public housing as a place where poor people live, lots of single mothers with children, lots of young men without jobs in the formal economy. That's not how public housing began in this country. Public housing began during the Great Depression in President Franklin Roosevelt's New Deal. It was not for the poor, but for lower middle-class families, middle-income families, with good jobs, but who could not find adequate housing because of the collapse of construction during the Depression that led to a housing shortage. The first New Deal agency, the Public Works Administration, created the first public housing in this country, and everywhere it built it, it segregated it, creating separate projects for whites, separate projects for African Americans, frequently creating segregation where it hadn't previously existed. The great African American poet, novelist, playwright, Langston Hughes, wrote in his autobiography that he grew up in an integrated downtown Cleveland, Ohio neighborhood. Integrated is not how we think of central Cleveland today. But Langston Hughes said he went to an integrated high school where his best friend was Polish. He dated a Jewish girl in that school. It was an integrated high school in an integrated neighborhood. But the Public Works Administration, in violation of its Fifth Amendment obligations, demolished housing in that neighborhood to build two separate projects, one for whites, one for African Americans, creating rigid segregation where it hadn't previously existed. Here in Connecticut, the Public Works Administration built one project in Stamford called Fairfield Court. It was 146 units of housing designated by the Public Works Administration as for whites only. Federal and state regulators, flouting their constitutional obligations, protected and sometimes insisted upon practices of national banks, savings and loans, and other institutions that redlined African American neighborhoods, denying mortgages to black applicants who lived in low-income urban areas, as well as to those who wished to move to newly created suburbs where poverty wasn't concentrated. These new suburban communities mushroomed in the immediate post-World War II period. For the most part, developers of these new suburbs were bigots who, if free to discriminate in their private capacities, would have refused sales to African Americans. But their racial bias was irrelevant. They required federal subsidies from the Federal Housing and Veterans Administrations to build these projects because banks would not lend them money without a federal guarantee. We were not yet a suburban country, and bankers were skeptical that the government would be able to induce white families to leave urban areas and relocate. If officials of the Federal Housing Administration and Veterans Administrations had kept their sworn oaths to uphold the Constitution and required non-discrimination by the builders, their private bigotry would have been inoperative, and the new suburbs, affordable at the time to both blacks and whites, would have been open to all. The imposition of metropolitan segregation was not the action of rogue bureaucrats working for the Federal Housing and Veterans Administrations. The policy was spelled out in writing in the FHA's underwriting manual, distributed to appraisers all over the country to guide them in their decisions to recommend developer proposals for federal guarantees for their loans. The manual explicitly said that no loan guarantees could be given to developers of non-segregated communities. It went so far as to say that an appraiser couldn't even recommend for a federal bank guarantee a loan to a developer of an all-white community if it was going to be located near a black neighborhood. In my book, The Color of Law, there's a photograph of a 6-foot-high, half-mile-long concrete wall in Detroit that the developer was required to create by the FHA to separate his all-white project from a nearby black neighborhood. The notion of de facto segregation is utter nonsense. These particular practices had enormous consequences that reverberate to this day. In the 1940s and 50s, when the Federal Housing and Veterans Administrations subsidized white returning war veterans and other urban white households to relocate to newly created suburbs while prohibiting African Americans from participating in this program, the white beneficiaries did not expect to get rich as a result. With a post-war housing shortage, they were desperate for a place to live. The early suburban houses for these lower middle-class families were inexpensive, a bit more than $100,000 in today's money. Nobody expected these properties to wildly appreciate in value as the years went by. But today, those homes are worth, depending on the part of the country that they are located in, $200,000, $300,000, $400,000, $500,000, in some places $1 million or more. Owners of those homes and their descendants gained unexpected wealth from the value appreciation of those modest houses. They used that wealth to send their children to college. They use it to subsidize their retirements. They use it to cushion temporary unemployment or cover medical emergencies. And, perhaps most importantly, to bequeath wealth to their children and grandchildren, who then had down payments for their own home purchases, as well as savings to pay for expensive college educations. African Americans, many of whom, as I said, could have afforded those $100,000 homes in the mid-20th century, but were barred by federal government policy from purchasing them, gained none of that wealth. Today, African American family incomes are, on average, about 60% of white family incomes. You would think that if the income ratio was about 60%, the wealth ratio would be about the same. You can save the same amount of money from the same incomes. But the wealth ratio is not 60%. It's nothing like it. African American household wealth is now about 12% of white household wealth. That enormous disparity between the 60% income ratio and the 12% wealth ratio is largely attributable to unconstitutional and unlawful federal housing policies practiced in the mid-20th century. The racial wealth gap thus created explains much of the racial inequality in America today. The most obvious consequence is that without intergenerational wealth inheritances, Black households do not typically have the ability to make down payments on homes and are more likely to be renters than owners. About 70% of white families own their own homes. Only about 40% of Black families do so. And because of the appreciation of single-family homes in the suburbs that were created by the FHA and the VA, that were affordable, as I said, at the time to both Black and white middle-class households, those African Americans who are now homeowners tend to own them in homes in neighborhoods with fewer resources and amenities. Black homeowners and renters live in more overcrowded, more polluted neighborhoods with fewer markets selling fresh and healthy foods, less access to jobs and transportation to get to those jobs, fewer city services, fewer primary care physicians, fewer bank branches, and more violence and stress. Beyond federal housing programs, the color of law describes many other policies at all levels of government, many racially explicit, and others that barely disguise the discriminatory racial motivation. Terming all of this de facto segregation implies no requirement for remediation. Many Americans, I'm sure many of those, perhaps all of you in this room, feel badly about living in a segregated country. But with its origins so hidden, it has been difficult to imagine what might be done to fix it. It's too easy to believe that what happened in so unspecified a way can only be undone in an equally mysterious and accidental fashion. In 1968, in the wake of the assassination of the Reverend Dr. Martin Luther King Jr., Congress passed and President Lyndon Johnson signed the Fair Housing Act that banned public and private racial discrimination in the sale and rental of housing, reenacting what had already been prohibited by the Civil Rights Act of 1866 and the post-Civil War constitutional amendments. And then in June 1968, a month and a half after the passage of the Fair Housing Act, the Supreme Court concluded in the underappreciated case of Jones v. Mayer that it had been wrong in the 19th century. The Civil Rights Act of 1866, the justices now found, had actually been a reasonable implementation of the 13th Amendment's authority for Congress to ban the badges and incidents of slavery, including private as well as public discrimination. The justices offered no remedies for the court's instigation of nearly a century of unlawful judicial imposition upon African Americans of second-class citizenship, with its enormous multi-generational consequences. Let bygones be bygones, was the court's view, with the 1883 ruling deemed only an honest mistake of justices who had somehow misinterpreted Section 2 of the 13th Amendment. To understand the seriousness of this mistake, consider a lower court opinion from 3 years before the 1968 Jones v. Mayer decision. In 1965, did I say? Yeah, 1968, Jones v. Mayer decision. In 1965, John Lewis and other civil rights leaders applied for a permit to march from Selma to Montgomery to protest Alabama's nearly universal denial to African Americans of the right to register to vote. The state rejected the permit application, claiming that the burdens of police protection and highway closure were too great for the march to take place. The activists sued in the court of Federal District Judge Frank Johnson, seeking an order to allow it. Judge Johnson was initially not convinced that the movement's First Amendment right to protest outweighed the public inconvenience of closing a highway and risking violence. But conscientiously, he evaluated the request for permission by researching the exclusion of African Americans from voting in Alabama. He created a table that listed counties in Alabama's Black Belt with month-by-month data during the prior half-dozen years, showing the number of blacks and whites who were eligible to vote and those who were permitted to register. It was 0 or nearly so in almost all cases for the black citizens who had attempted to register. The judge then not only ordered that the marchers be given a permit, but included his table as an appendix to the ruling. He stated that the remedy for a constitutional violation, and I'm going to quote, should be commensurate with the enormity of the wrong, unquote, that require it. This principle of proportionality is commonplace in American civil law cases. Remedies for suffering ought to be scaled to the seriousness of an injury. But in constitutional law, it's not honored, although it makes perfect sense that it should be. Here's another case for you to consider, with which you're all familiar. In 1954, the Supreme Court in Brown v. Board of Education ruled that segregated public schools were unconstitutional. The civil rights lawyers who pursued that case were cautious. They proceeded with the theory that with some trepidation, fearing that the court would never go so far as to overturn the separate but equal doctrine. The civil rights lawyers thought that perhaps all they should seek is true equality between separate black and white schools. But they rolled the dice and challenged Plessy v. Ferguson head-on. I can't quarrel with their practical judgment, but if students in Kansas, South Carolina, Virginia, Delaware, and Washington, D.C., the districts that were consolidated in Brown, if those students had been denied an equal education, was the remedy that henceforth schools in those districts should be desegregated? Was that remedy proportional to the harm that those students had suffered? Were those students entitled, perhaps, to compensation for their unequal educations? Judge Frank Johnson's principle of proportionality suggests so. How should his principle be applied now to the harms of residential segregation? Well, readers of The Color of Law and attendees at many meetings I've spoken to like this frequently ask me, what can we do about it now? In an attempt to answer that question, I recruited my daughter, Leah Rothstein, a housing expert, much more than I am, to co-author a sequel, a book published last year called Just Action. The book offers practical advice about things that all of us can do. Like the civil rights lawyers in Brown, when you attempt to redress the harms of segregation, you'll have to balance what is practical with what would be proportional. But I hope, as you pursue practical action, you'll always keep in mind how short practicality falls and what would be truly proportional. There's yet no public or political will to adopt national remedies that are commensurate with the enormity of the damage segregation has caused. Yet, although federal policy played an important role in the imposition of racial segregation, its sustenance is now often maintained and even exacerbated by local programs and practices. The 20 million Americans who participated in racial justice protests and marches in 2020, black, white, and other ethnicities, from low income as well as middle class and affluent neighborhoods, comprised the potential base for a reinvigorated activist civil rights movement that could begin the redress of segregation in their own communities. After the demonstrations were over, too many went home, put Black Lives Matter signs on their lawns and windows, and did nothing further to make their posters call a reality. In large part, they did not know what to do, and nobody asked them to do anything. So our 2023 book, Just Action, describes many local programs and practices that reinforce racial segregation and suggests how community groups could challenge them to win significant victories. Once federal policies led to the creation of two societies, one black and one white, race-neutral policies and practices can exacerbate the inequality. In too many cases, post-1968 federal programs were facially race-neutral, but had a disparate impact on African Americans, reinforcing segregation, not diminishing it. Although federal, these policies with disparate impact require implementation that is subject to local control and reform. The most egregious of such policies are zoning rules that lock in the segregation of suburban areas created when homes were affordable to black and white middle-class families. Connecticut is one of the worst offenders nationally in the use of zoning to preserve segregation. In our book, Just Action, we focus on two metropolitan areas in this state as examples. 2/3 of West Hartford, for example, is zoned for single-family homes only. 80% of West Hartford residents are white or Asian. In neighboring Hartford, only 18% of the residents are white or Asian. The remaining 82%, mostly Black and Hispanic, are almost all renters. In Hartford, 40% of all housing units are reserved for the poor. In some neighborhoods of Hartford, it's as high as 70%. It would be hard to find a better example of unconstitutional and unlawful state-sponsored segregation, but not that hard. All we have to do is go down to New Haven. There, the almost all-white suburb of Woodbridge zones 98% of its residential land for single-family homes only. In New Haven itself, only 1/3 of the population is white or Asian, and most of the rest are renters. Woodbridge planners propose changing the zoning of a small part of the community so that firefighters, police, teachers, and other middle-class families that serve the suburb could afford to live there. It was rejected in the face of enormous community opposition. Residents claimed that multifamily dwellings in Woodbridge would attract people from New Haven who would climb over fences to steal cars and hurt children. Woodbridge, by the way, is a liberal democratic town. A civil rights group here, the Open Communities Alliance, is challenging Woodbridge's zoning and racial exclusion. But what is even more essential is mobilizing those Woodbridge residents, some of whom participated in the Black Lives Matter demonstrations, but who are silent in the face of noisy, bigoted opposition. Zoning is a purely local issue to preserve segregation that the federal government created. The federal government has nothing to do with zoning. There are many other local policies with a disparate impact. One is a tax credit program adopted 20 years after the Fair Housing Act for builders of low-income housing. States adopt regulations to determine which projects receive the subsidy. They often include incentives to place the projects in low-income communities. For example, to win credits, developers are expected to demonstrate community support, much less likely to be won in white middle-class neighborhoods. Another is the Section 8 voucher program, authorized in 1974, that purported to enable low-income households to escape purely resourced communities. But it has resulted in only 5% of voucher holders living in high-opportunity places, and African-American recipients are less likely to do so than whites. The result, Section 8 has reinforced segregation. Program rules have made this nearly inevitable. Administered by local public housing authorities, the voucher was designed to permit households to spend no more than 30% of their income on rent. Vouchers are to make up the difference between this household's 30% of income share and about 10% below the midpoint of all metropolitan area rents. The result has been that recipients are mostly unable to afford most area units, those in the high opportunity places to which the vouchers had been intended to give access. The affordable lowest cost apartments are almost all located in lower income neighborhoods. In 2010, the Inclusive Communities Project of Dallas sued its housing authority, claiming that the operation of Section 8 violated the Fair Housing Act by intensifying segregation. A settlement required two housing authorities in the Dallas region to base voucher amounts on typical rents of smaller local areas, so that the maximum Section 8 contribution would be higher in higher cost areas, and lower costs were less. The Department of Housing and Urban Development then required housing authorities in 23 additional metropolitan areas to adopt this small area rent program. Beginning next year, housing authorities in another 41 metropolitan areas must also use the small area rent calculations. Other housing authorities are permitted voluntarily to adopt them without a HUD mandate. Community groups should monitor their public housing authorities to ensure that they faithfully implement the small area rent standard where required, and campaign for other authorities to use them voluntarily. With the add of the metropolitan areas, almost half of Section 8 households nationwide will theoretically soon have access to higher opportunity communities if landlords will agree to rent to them. Building owners in more middle-class areas frequently refuse to accept Section 8 applicants. The federal government allows this, but 20 states and over 100 localities have outlawed such discrimination. Campaigning for the prohibition elsewhere is another opportunity for local activists, as is enforcement, where discrimination is banned on the books, but still practiced much more often than not. Another example of racially disparate impact is our property tax system. Unlike the tax credit and voucher programs I just mentioned, property tax policies and practices are purely local, with no federal participation. In almost every city and county nationwide, Black homeowners pay property taxes at a higher rate relative to the value of their homes than white homeowners do. There are many reasons for this. One is that most city and county assessors don't physically inspect properties annually. Sometimes they wait decades to reassess, with an annual inflation adjustment as a substitute. Between the actual physical assessments, homes in white neighborhoods tend to appreciate in value faster than homes in black neighborhoods. Over time, assessed values of houses in white neighborhoods fall farther below their real market values than assessed values of homes in black neighborhoods. The result is that African Americans usually pay higher taxes than whites pay relative to their property's market values. Renters in lower income areas also suffer because, for similar reasons, their landlord's property taxes are also discriminatorily high, with the costs passed on to tenants. Black households, owners and renters, then bear an unfairly greater burden of financing their city and counties' schools, libraries, fire departments, and other public services that local taxes support. The inequality in neighborhoods was created in large part by the federal government, but assessment practices that build on that inequality and increase it are a purely local problem. The discriminatory system is no mystery. City and county assessors know it, admit it, but they won't have an incentive to fix it unless forced to do so. That's where a local activist group can engage. To build on such relationships to create committees that can redress segregation, a group might begin by learning how its own city segregated. In several communities that we profile in this new book, Just Action, Charlottesville, Virginia, Modesto, California, Rochester, New York, residents search racially restrictive clauses in their property deeds. These covenants, sometimes required by federal agencies for subsidized suburban developments, specified that the property could only be owned or occupied by whites. In some cities, activists have used racially restrictive covenants to illustrate metropolitan area educational campaigns with lectures at churches, synagogues, service clubs, schools, and open-air tours. As residents learned more, opportunities and motivation for remedy presented themselves. The deed clauses are dramatic and visual, but their impact on current efforts to challenge segregation can extend beyond helping a community learn its history. The document's signature pages frequently name the banks, realtors, developers, and government agencies that impose the racial segregation. For example, covenants publicized in the cities that I just mentioned, that we described in Just Action, identified the perpetrators of segregation. Banks like Wells Fargo, real estate firms like Coldwell Banker, the American Trust Company, corporations like Eastman Kodak, and various other realtors and builders, as well as local and federal government agencies. Community groups can organize campaigns to press those firms that created their city's segregation to take an active role, political and financial, to remedy it. In some cases, the original signatories later merged with larger firms. Successor firms should be considered to have absorbed not only their predecessors' assets and liabilities, financial, but their moral liabilities as well. Residents can urge and expect these institutions to contribute to remedies for segregation. Not all ongoing segregation results from the disparate impact of facially race-neutral policy. Openly discriminatory violations of the Fair Housing Act also continue and beg for remedy by local groups. Newsday, a newspaper on Long Island, east of New York City, investigated continued unlawful practices of real estate agents in 2019 with what is called a paired testing program, sending pretend home buyers, one black, one white, to a real estate agency a short time apart. The testers came with nearly identical financial records, ability to afford the home, family characteristics, and professional backgrounds. The testers wore hidden body cameras to record their interactions with the agents. Newsday placed its reports, including videos of these interactions, on the web with no paywall. You can all look at it. and see these interactions between buyers and realtors yourselves. Newsday reported that black testers receive discriminatory treatment today, in 2019, in 50% of their realtor interactions. 50%. For Hispanics, it was 40%. For Asians, 20%. They were shown different homes and different areas than equally qualified white pairs. Other race testers were given different information about the same neighborhood. One told it was a great place to live, the other that he or she wouldn't want to live there. Reporters also observed refresher courses required of realtors for license renewal, like your CLE courses that some of you are here to take. States require that non-discrimination training be included in these refresher courses, but it's given short shrift. In one course that the reporters observed, the instructor, a former president of the local Realtors Association, explained that non-discrimination is like highway speed limits. If you're in a rush, you get to choose whether you break the law. Quote, "There's no reason to think that the behavior of realtors on Long Island is much different from those in any metropolitan area nationwide. Black homeowners who seek to get information from real estate offices have no way to realize that they're experiencing unlawful discrimination. They can't know that a white client received different and better information about homes for sale. The only way to identify this unlawful discrimination is with a pair testing program like the newspaper sponsored. Similar testing can uncover discriminatory practices by landlords of rental units. Fair housing centers in cities across the country conduct pair testing, but with only small federal grants and some additional foundation support, the centers don't have funds to do much of this testing. Local civil rights groups could recruit volunteers to be testers. They're in short supply in most communities, and the groups could raise funds to support the work of these fair housing centers. When fair housing centers uncover discrimination, they can and do pursue legal action against an offending realtor or landlord. Activists can go further and campaign to force state licensing agencies to lift the accreditation of agents who discriminate. New York State violated its 14th Amendment obligations in the last few years when it renewed licenses of agents who took courses with deficient fair housing training, such as those monitored by Newsday. Neighborhood inequality that discriminatory practice exploits may have been created by the federal government, but remedies such as those I've just described are in local control, like reform of tax assessment policy, enforcement of non-discrimination in the sale and rental of housing is within the capacity of local organizations. Although progress has been made in some areas of American life, most notably in the growth of a well-educated black middle class that has desegregated many workplaces, we are more segregated residentially than we were in 1968. Civil rights advocates devote too much of their time and effort proposing federal reforms with little chance of enactment. The place to start is local, mobilizing neighbors to act to redress segregation in their own communities. Just Action recounts many opportunities like those I have just described for engaged citizens and residents to redress segregation in their own communities, making a significant dent. If we take our responsibility as Americans seriously, we will accept an obligation to remedy unconstitutional programs enacted in our name and blessed by a rogue Supreme Court. I hope that you will agree and join with others in your communities to redress the badges and incidents of slavery that surround us still. Thank you very much for your attention.